Directors of a company. Nature and duties of directors. Director appointed to the board of a company. Board of directors, collective body of the directors of a company. Managing director, director by virtue of articles, agreement or a board resolution or a resolution general meeting is entrusted with substantial powers of management of the company and includes a director occupying the position of managing director. Whole-time director includes a director in the whole-time employment of the company. Specific duties under section 166, a director to act in accordance with the articles, for the benefit of its members, act in good faith, protect interests of company, employees, shareholders, community and the environment, exercise duties with care, skill, diligence and exercise independent judgment, not involve in conflict of interests, not achieve any undue gain or advantage and not assign his office. Type and appointment of directors. Every company shall have a board of directors consisting individuals as directors. Minimum number of 3 directors in case of a public company, 2 directors in case of a private company and 1 director in case of a one-person company. Maximum of directors can be 15. A company may appoint more than 15 directors after passing a special resolution. Such class or class of companies as may be prescribed shall have at least 1 woman director. Every company shall have at least 1 director who stays in India for a minimum of 182 days during the financial year. Every listed company shall have at least 1/3 of the total number of directors as independent directors. Any fraction shall be rounded off as 1. Where articles are silent, subscribers to the memorandum deemed to be the first directors of the company. Every director be appointed by the company in general meeting. Every person proposed as director shall furnish his director identification number and a declaration that he is not disqualified and shall also give his consent, and such consent filed within 30 days of his appointment. At every annual general meeting, not less than 2/3 of the total directors are liable to retire by rotation and be appointed by the company in general meeting. The total number of directors shall not include independent directors. The first directors retire at the first annual general meeting. At every subsequent AGM, 1/3 of directors as are liable to retire by rotation shall retire. The directors to retire are those longest in office. Between persons who became directors on the same day based on agreement among themselves or by lot. At an AGM, a director retires. The company fills up the vacancy, appointing the retiring or some other person. If the vacancy is not so filled up and the meeting not expressly resolved not to fill the vacancy, the meeting shall stand adjourned till the same day in the next week. If at the adjourned meeting it is not filled up and the meeting not expressly resolved not to fill the vacancy, the retiring director is deemed reappointed unless resolution for reappointment was lost, or the retiring director expressed his unwillingness to be so reappointed, or he is not qualified or is disqualified for appointment, or a resolution whether special or ordinary is required for his reappointment by virtue of the act. Board has the power to appoint an additional director if empowered by articles, and the additional director shall hold office up to the next annual general meeting. Board can also appoint an alternate director if authorized by articles or by a resolution of general meeting, and such alternate director shall act for a director during his absence for a period not less than 3 months from India, and he shall vacate when the director returns to India. To be appointed as an alternate for an independent director, one needs to be possessing qualifications of an independent director. Company's board is also authorized to appoint a nominee director from any institution or government, and if the office of any director appointed in a general meeting is vacated before his term, such a casual vacancy can be filled by the board of directors, but such appointment shall be subsequently approved by the members in a general meeting, and any person so appointed shall hold office only up to the residual term of the director in whose place he is appointed. Minimum 2 independent directors are required to be held by a public company having a paid up capital of rupees 10 crore or more, or a public company having turnover of 100 crore rupees or more, or a public company which in aggregate has outstanding loans, debentures and deposits exceeding rupees 50 crores. Any intermittent vacancy of an independent director shall be filled up by the board at the immediate next board meeting or 3 months from the date of such vacancy, whichever is later. The position of independent director is unique in that he is not a managing director, nor a whole-time director, nor a nominee director. He is a person of integrity, possessing relevant experience and expertise in disciplines related to company's business. He is not a promoter, nor related to promoters or directors, has no pecuniary relationship other than remuneration, neither himself or relatives hold position of a key managerial personnel of the company, and none of his relatives is holding any security of or interest in the company, nor is he or they indebted to the company. An independent director is not attracting provisions on retirement by rotation. He is not entitled to any stock option but may receive remuneration by way of fee, and his office is up to 5 consecutive years but eligible for reappointment on passing a special resolution. He can hold office for not more than 2 consecutive terms, and any change affecting his status as an independent director is required to give declaration confirming on the criteria of independence. Every listed company is required to have at least one woman director. Every other public company having a paid up share capital of rupees 100 crore or more or turnover of 300 crore or more shall appoint at least one woman director. Any intermittent vacancy of a woman director to be filled up by the board at the immediate next board meeting or 3 months from the date of such vacancy, whichever is later. A listed company can opt for appointment of a small shareholders suo motu considered as an independent director. It can also have a small shareholder director elected by the small shareholders upon notice of not less than 1000 small shareholders or 1/10 of the total number of such shareholders, whichever is lower, not liable to retire by rotation, tenure not to exceed 3 years, on the expiry of first term not eligible for reappointment, not to hold the position in more than 2 companies at the same time as a small shareholder director. The second company shall not be in a business competing with the company. Directorships, including alternate directorships, not to exceed 20 at the same time. Maximum number of public companies shall not exceed 10, and members by special resolution are at liberty to specify lower number of companies in which a director of the company may act as a director. Disqualification specified under section 164, unsound mind declared by competent court, undischarged insolvent or applied to be adjudicated insolvent, application is pending, convicted by a court and sentenced to imprisonment not less than 6 months, order disqualifying passed by a court and the order is in force, and he has not paid any calls and 6 months have lapsed from the last day fixed for payment of call, or convicted of offence related to related party transactions during the preceding 5 years. A director is not eligible to be appointed or reappointed for offence committed by the company where the company has not filed financial statements or annual returns for a continuous period of 3 financial years, or has failed to repay deposits, debentures or interest thereon, or pay dividend declared, and failure continues for 1 year or more. And in respect of a private company, articles can provide for any additional disqualifications for appointment as a director. Vacation of office results from section 167, where a director incurs disqualification specified in section 164, absents all meetings during 12 months, or contravenes section 184 relating to entering into contract in which he is interested, or he is disqualified by an order of a court or a tribunal, or he is convicted of an offence and sentenced to imprisonment for not less than 6 months. Vacation of office also results when he is removed in pursuance of the provisions of this act, or having been appointed by virtue of his holding any office or other employment, he ceases to hold such office or other employment in the company. A private company may by its articles provide any additional grounds where all directors vacate their offices under any disqualification. The promoter or the central government shall appoint the required directors to hold office till directors are appointed by the company in the general meeting. A director may resign by giving a written notice to the company, and the board shall take note of it, make the necessary filings with the registrar of companies. The fact of resignation will be incorporated in the report of directors to be presented in the immediately following general meeting. Resignation takes effect from the date received by the company or the date mentioned in the resignation. Director is also eligible to forward a copy of of his resignation to registrar within 30 days. Pursuant to section 169, a director may be removed by ordinary resolution after giving opportunity of being heard. A special notice is required to remove a director or appoint somebody at the meeting he is removed. The provision will not apply in respect of directors appointed by principle of proportionate representation. On receipt of notice to remove the director, the company copies the director and he shall be entitled to be heard at the meeting. Where the director makes a representation and requests notification to members, the company shall do so. If copy is not sent, the director may, besides his right to be heard orally, require his representation to be read out at the meeting. If the company approaches tribunal stating circulation is being used for getting undue publicity and tribunal accepts company's view, representation need not be sent nor it be read out at the meeting. Vacancy created by removal may be filled up by appointing another person provided special notice has been given. Else it can be filled up as a casual vacancy. The new incumbent will hold office till the residual tenure of his predecessor. Section 173 deals with meetings of board. States first meeting of the board to be held within 30 days of incorporation. Thereafterwards 4 meetings to be held every year. Gap between 2 board meetings should not be more than 120 days. Participation of directors in a board meeting may be either in person or through video conferencing or other audio-visual means, with recording and storing of proceedings of such meetings done along with date and time. A meeting of the board can be called by giving a clear notice of 7 days in writing, sent by hand delivery or by post or by electronic means. Meeting may be called at a shorter notice, provided at least one independent director shall be present at the meeting. In case of absence of independent directors from such meeting of the board, decisions of such meeting shall be circulated to all directors and they shall be final only on ratification thereof by at least one independent director if any. Quorum in respect of a meeting of a board of directors shall be 1/3 of its total strength or 2 directors, whichever is higher. Participation by video conferencing or by audio-visual means is included for purposes of quorum, where at any time the number of interested directors exceeds or is equal to 2/3 of the total strength. Directors who are not interested and present at the meeting, being not less than 2, shall be the quorum. Where a meeting of the board could not be held for want of quorum, the meeting shall be adjourned to the same day, same time and place next week, or if that day is a national holiday, till the next succeeding day. Passing of resolution by circulation under section 175. Resolution is circulated in draft to all directors or members of committee at their addresses in India by hand delivery, post, courier or through electronic means. It is approved by a majority of the directors or members who are entitled to vote on the resolution. It is noted at a subsequent meeting of board or committee thereof and made part of the minutes of such committee. Where not less than 1/3 of directors require, the resolution must be decided at a meeting. The chairperson shall take it to be decided at a meeting of the board. A company may pay sitting fee to a director for attending meetings of the board or committees thereof. Such sum as may be decided by the board of directors. It shall not exceed rupees 1 lakh per meeting of the board or committee thereof. Sitting fee will be on par with each other between directors, be it independent director or woman director. The board of a listed company shall constitute an audit committee comprising of a minimum of 3 directors, with independent directors forming a majority, looking into remuneration in terms of appointment of auditors, review and independence of audit process, examination of financials, approval of transactions with related parties, scrutiny of intercorporate loans and investments, valuation of undertakings or assets of the company, evaluation of internal controls and risk management systems, and monitoring and use of funds raised through public offers. Audit committee shall have authority to investigate any matter in relation to the items referred to it by the board. An audit committee can make an omnibus approval for related party transactions subject to conditions. Where audit committee does not approve the transaction, it shall make its recommendations to the board. The auditors and the key managerial personnel shall have the right to be heard in meetings of the audit committee. Where board not accepted recommendation of the committee, it shall disclose it in the report along with its reasons. The board report under section 134 shall disclose the composition of an audit committee. Every listed company shall establish a vigil mechanism for directors and employees to report genuine concerns. A nomination and remuneration committee pursuant to section 178 can be formed by the board of directors of every listed company, consisting of 3 or more non-executive directors, out of which not less than 1/2 shall be independent directors. It shall identify persons who are qualified qualified to become directors and who may be appointed in senior management. The committee shall specify the manner for effective evaluation of performance of board, its committees and individual directors. It may recommend to board a policy on the remuneration for directors, key managerial personnel and other employees. Salient features of the policy along with web address, if any, shall be disclosed in the board's report. The board of directors has wide powers to exercise all such powers and to do all such acts as the company is authorized to do, subject to provisions contained in articles, act, memorandum or regulations made by the company in general meeting. The board shall not exercise any power which is required to be exercised by the company in general meeting. Board has wide powers to exercise in its meetings by means of resolution, to make calls, to authorize buyback, to issue securities, to borrow monies, to invest funds, to grant loans or give guarantees, to approve financial statement and board's report, to diversify business, to approve amalgamation, merger or reconstruction, and to take over or acquire substantial stake in another company. Of its powers, the board by a resolution may delegate to MD, manager or a committee of directors or any other principal officer 3 powers: to borrow monies, to invest the funds of the company, and to grant loans or give guarantees, subject to limits to be specified. There are 4 specific powers which the board can exercise only subject to the consent of the company by a special resolution: to sell, lease or otherwise dispose of the whole or substantially the whole of the undertaking of the company, undertaking wherein investment exceeds 20% of its net worth or it generates 20% of its income; to invest otherwise than interest securities, compensation received from any merger or amalgamation; to borrow money where borrowings exceed aggregate of its paid up share capital, free reserves and securities premium; and to remit or give time for repayment of any debt due from a director. A non-government company in existence for not less than 3 financial years may contribute any amount to any political party. Such contribution can be made directly or indirectly, shall be authorized by a resolution passed at the meeting of board of directors. Every company in its profit and loss account shall disclose the total amount contributed during the financial year. It shall be made by an account payee check, bank draft or by use of electronic clearing system through a bank account. Expenditure on advertisement in any publication where such publication is by or on behalf of a political party or for advantage of a political party shall be deemed to be a contribution for a political purpose. Disclosure under section 184. Every director at the first meeting of the board in which he participates as a director and thereafter at the first meeting of the board in every financial year or whenever there is any change in the disclosures already made, then at the first board meeting held after such change disclose his concern or interest in any company, companies or bodies corporate, firms or other association of individuals where he holds more than 2% shareholding or is a promoter, manager, CEO of that body corporate, or with a firm or other entity where he is a partner, owner or member. Where any director is interested or concerned subsequently, if he becomes concerned or interested after the contract or arrangement is entered into, he shall disclose his concern or interest forthwith when he becomes concerned or interested, or at the first meeting of the board held after he becomes so concerned or interested, he shall disclose at the meeting in which the contract or arrangement is discussed and shall not participate in such meeting. A contract entered into without disclosure or with participation is voidable at the option of the company. No company shall advance any loan or give any guarantee or provide any security for any loan taken by a director of the company or of a company which is its holding company or any partner or relative of any such director or any firm in which such director or relative is a partner, with the exception where a special resolution is passed by the company in general meeting and the loans are utilized by the borrowing entity for its principal business activities. The restrictions under section 85 on loans to directors is not applicable in 3 specific cases. 1. For giving of any loan to a managing or whole-time director as a part of conditions of service as per a scheme approved by the members by a special resolution, or a company which in the ordinary course of its business provides loans or gives guarantees or securities, or any loan made by or guarantee given by a holding company to its wholly owned subsidiary for utilization by the subsidiary company for its principal business activities. No company shall enter into related party transactions except when the board gives its consent. The transactions may relate to sale, purchase or supply of any goods or materials or selling or buying of property of any kind. It may also be a proposal of leasing, acquiring property or availing or rendering of any services. The contract might also cover appointment of agent for purchase or sale of goods or property, or related parties appointment to office or place of profit, along with an underwriting contract for subscription to the securities of the company. Where the transaction value is beyond specified limits during a financial year, it is required to get prior approval of company by resolution in a meeting. No restrictions shall apply to company transactions in its ordinary course of business unless it is not on an arm's length basis. No board member shall vote on a resolution if such member is a related party. Passing the resolution not applicable for transactions between a holding company and its wholly owned subsidiary. Every contract shall be referred to in the board's report to the shareholders along with justification. Contracts entered into by a director or employee without approval from board or by a resolution in the general meeting, if not ratified at a meeting within 3 months, shall be voidable at the option of the board or shareholders, and the director's consent shall indemnify the company against any loss incurred therefrom. Guidelines in respect of appointment of managing director, manager or whole-time director. No coexistence of managing director and a manager. Term not to exceed 5 years at a time. Not to employ one who is below 21 years or attained 70 years. Beyond 70 permitted by passing a special resolution. Who is an undischarged insolvent or has at any time been adjudged so, or has suspended payment to his creditors or made a composition, or at any time convicted and sentenced for more than 6 months. Section 197, ceiling on managerial remuneration. A public company shall not exceed 11% of net profits under section 198. Company in general meeting may authorize exceeding 11% subject to provisions of schedule 5, except with the approval of the company by special resolution. The remuneration shall not exceed 5% of net profits to any one of managing director, whole-time director or manager. If more than one, not to exceed 10% to all such directors and managers taken together. Remuneration to directors not to exceed 1% of net profits if there is an MD or WTD or manager, 3% otherwise. Progress review on directors. On minimum directors, the board for a private company will have 2 directors, and for a public company, minimum directors is 3. Maximum is 15 for both private and public, but a company can increase the number beyond 15 by passing a special resolution in the meeting of shareholders. Of the directors, only 1/3 can be permanent, in the sense balance has to be retiring and reappointable. Within 30 days of appointment of a director, his consent has to be filed by the company with the ROC. A return containing appointment of directors and other key managerial personnel and changes therein shall be filed with the registrar within 30 days of appointment or change. Director identification number has got the acronym DIN. At every annual general meeting, after the first AGM of the rotational directors, 1/3 or nearest to 1/3 are liable to retire by rotation. Additional directors appointed by the board continue only up to the next annual general meeting. A director may resign by giving written notice to the company. If a director becomes absent from all the meetings held during a period of 12 consecutive months, his seat will become vacant. This is irrespective of whether his absence was with or without leave of absence of the board. A company cannot remove a director if the director was appointed by the tribunal. There should be minimum 4 board meetings in a span of 12 months or 1 year, and between 2 board meetings, the gap should not be more than 120 days. Where a public company has a paid up capital of rupees 10 crore or more, or its turnover is 100 crore or more, or it has got outstanding loans or debentures and deposits of rupees 50 crore or more, exceeding 50 crore to be exact. If any one of these conditions are fulfilled, it is compulsory for a company to have an independent director. An independent director doesn't have any material, financial, pecuniary relationships with the company, its promoters, directors, or its holding company, subsidiaries or associates. The term of an independent director will be up to 5 consecutive years, and his subsequent reappointment has to be with the support of a special resolution. All reappointments require a special resolution, and normally shareholders approve the appointment of independent directors in their meeting. There is a concept called small shareholder director. He can be appointed for a maximum period of 3 years and it is only a one-time appointment. There cannot be any reappointment in case of small shareholder directors. Small shareholder means a shareholder who has got value of shares with him not more than rupees 20,000 in face value. To elect a director, small shareholders need the support of 1000 shareholders or 10% of the total number of small shareholders. A woman director is required to be appointed by a company, minimum one number, where the paid up capital is 100 crores or more or turnover is 300 crores or more on the last date of the latest audited financial statement. Whole-time director is a director in the whole-time employment of the company. A managing director and a whole-time director should meet the minimum age requirement of 21 years. 70 years is the maximum age for a managing director, but shareholders can give approval for the appointment once a person crosses 70 years for his continuation or appointment as a managing director, whole-time director or manager. ESOP treats a director as an employee. The director may be whole-time director or not, but ESOP doesn't apply to independent director because he is not treated as an employee. A sitting fee of not exceeding rupees 1 lakh could be paid per meeting of the board or per meeting of the committee of the board. The managerial remuneration of a public company can have a remuneration not exceeding 11% of the net profits of the company, and the managerial remuneration is inclusive of remuneration to managing director and whole-time director. In the years of nil profit or inadequate profits, it is not obligatory for a company to pay remuneration to its directors in any financial year. A listed company shall constitute an audit committee comprising of minimum of 3 directors. Nomination committee assists the board in identifying prospective directors from among the members or employees or the team members of the company. A director who was removed from office cannot be reappointed by the board of directors in whatever capacity, be it a casual vacancy or additional director.